je ferai le même avertissement que Pierre. Je vais vous parler de choses terriblement ennuyeuses qui contrastent avec les débats assez fascinants de ce matin. Elles sont ennuyeuses parce qu'elles sont assez techniques, mais comme j'espère le montrer, les débats de ce matin informent et influencent la façon dont on applique les règles techniques dont Pierre et moi allons vous parler aujourd'hui, et dont Pierre vous a parlé aujourd'hui. Je dois aussi vous dire que je dois faire amende honorable parce que je vais commettre un crime de lèse-majesté qui est de parler en anglais, dans une institution francophone, étant moi-même francophone. Mais ceci est une bonne manière d'introduire la règle dont je vais vous parler, c'est que lorsqu'un comportement criminel ou illicite est autorisé, eh bien la responsabilité peut être partagée entre le sujet autorisé et le sujet autorisant. Donc s'il y a crime de lèse-majesté, ce crime est partagé avec les organisateurs. Bon, maintenant, la simple raison, c'est de la paresse. Tout le monde sait très bien que je suis paresseux. Toute ma recherche sur la responsabilité a été conduite en anglais, ce qui explique que je vais, pour les 14 minutes qui suivent, vous introduire quelques observations en anglais. As indicated by the program, the question I'm grappling with is the question of responsibility in a very specific situation, which is the situations whereby a regional organization has been authorized to use force. And as you know, there is significant practice in this respect. We remember NATO in Yugoslavia, NATO in Afghanistan. There is potential future practice, not later than the 12th of October this year. Security Council adopted Resolution 2071, whereby it took note, remember, of the ECOWAS readiness to take military action in Mali. And the Security Council added that it was itself ready to respond to the request of the transitional authorities of Mali regarding a possible international military force. So this may actually pave the way for additional practice of authorized use of force by regional organizations. So it's an extremely topical question. It's not, and questions of responsibility and questions of violations of international law by regional organizations are not a textbook case. Just remember the intervention of ECOMOG in Liberia and Sierra Leone. Of course, these were not authorized missions, but you might remember the very heavy-handed intervention by the Nigerian soldier within the framework of the ECOMOG mission, which actually raised a lot of doubt as to the conformity with the use in bello. So it's not a textbook case. It is a very topical topic, I believe, and it raises questions of responsibility which are a bit similar to those that have been addressed by Pierre. However, in my case, in the case of authorized regional organizations intervention, there is an added layer of intricacy in the sense that there is a delegation, not to member states, but there is a delegation to another international organization. So in this case, you have a twofold institutional veil. Now you have states acting behind the United Nations, steering the Security Council, on the one hand. On the other hand, you have those states providing means to the authorized regional organization. And of course, that dilutes even more the responsibility relation between the United Nations and the possible injured subject. So what's the regime of responsibility for these very intricate situation? Well, I'll start for the last 11 minutes. I'm very afraid of Barbara. I'll start with a few general remarks about the prerequisites, the preconditions for the question of responsibility to arise, before turning to a few problems with the rules that have been devised by the International Commission with regard to these specific situations. Well, the prerequisite, this is very elementary, this is embarrassingly elementary. We all know that the question of responsibility of these regional organizations only arises if they have legal personality. As such, this seems to be non-controversial, because if there is no legal personality, the organization is at best a joint organ. But usually these regional organizations like NATO, ECOWAS, African Union are deemed to be an international legal person. I mean, people claiming that the NATO is not an international legal person actually have been very marginal. These claims are very marginal. There are very few people. So the question of legal personality is not an issue. As highlighted by Pierre, and I concur with him in this respect, the second prerequisite is more difficult. That is the idea that regional organizations must be bound by some primary obligations. Of course, you could say that in this intervention, they're supposed to abide by international humanitarian law, customary international humanitarian law, at least those norms of IHL which are materially and functionally applicable to them. They're probably bound by the customary prohibition to use force. But more intricate is the question whether they're bound by the UN system, by the UN collective security system. Because they're not a party to the UN Charter. And so the question arises, are they bound by all the obligations that are inherent to the collective security system? And I think this is more intricate. You could use the idea of a unilateral act, of a unilateral promise by those organizations, and maybe these organizations that recognize themselves as Chapter 8 regional arrangement could be deemed to have made such a commitment to respect the UN Charter. But short of such a formal commitment, such a formal recognition as a Chapter 8 regional arrangement, I think there are some questions about the primary obligations in terms of use ad bellum of these regional organizations. And what about NATO, which has always shied away from recognizing itself as a Chapter 8 regional arrangement? So there are issues there, even with the African Union. When you look at the recent African Union Charter, the African Union Non-Aggression and Common Defense Pact, you see that the African Union is taking some liberty from the UN Charter and maybe providing indication that actually they don't deem themselves bound by the UN collective security system. Anyway, I don't want to speak about primary obligations. That's not my intention today. But like Pierre, I believe that this question is more difficult than it is often assumed. Well, let me turn to my second point, which is my main point, which is issues of responsibility. Well, what's the regime of responsibility for those specific situations of authorized enforcement operation by a regional organization? As recalled by Pierre, as you all know, the principle is rather simple. You know that responsibility, and that was the idea of Ancelotti, that responsibility is molded on the idea of nonconformity, nonconformity by a subject, and in that sense, responsibility follows attribution of conduct. So you have committed a conduct which is not in conformity with international law, you will incur responsibility. So this Ancelottian binary concept of responsibility. Well, as from the very start, we know that this was a little bit insufficient to capture all the situation we wanted to include in the system of responsibility. So from the very start, and I think Pierre recalled that, we felt the need to adjust this extremely simple, very simple blueprint. And these adjustments either took the form of special rules of attribution of conduct, like those that Pierre has mentioned, or in other cases, when it was not possible to attribute the conduct to the subject whose liability was at stake, we devised this all-embracing category of convenience, which is these situations of attribution of responsibility. And as Pierre has explained, there is a difference, is that in attribution of conduct is just a general rule. You are responsible, you incur responsibility for your own conduct, in the case your conduct is not in accordance with international law. In the case of attribution of responsibility, you incur responsibility for something which is not your conduct, for a conduct which is the conduct of another subject. And in the case of state responsibility, we've devised these ideas of coercion, complicity, and exercise of control over other subjects. Well, this second category, this idea of attribution of conduct, attribution of responsibility short of conduct, has proved extremely convenient in the case of the responsibility of international organizations. And And it has been a very useful, very convenient tool to capture situations like those of authorization to regional organization, which otherwise would have fallen beside the whole model of responsibility. I'm not going to talk about, this was done already, about this special situation of attribution of conduct, Article 7, and the controversial application in the Berami case. I mean, all this is a bit surreal, not only the application by the ECHR, but also the fact that the ILC says that it comes from the practice of the UN, whereas the UN says no, that they don't want this rule and that this rule has never existed in their own practice. You also, I think the discussion this morning also shows that very often, actually, the effective control remains with the member state. Just think about the red card holder procedure within NATO. I think it really shows that the control is with the member states. And it also shows that it's more regional international organization putting that structure and organ at the disposal of the member state and the UN rather than the other way around. But anyway, this was already tackled. These are special rules of attribution of conduct. I want to speak about, for the next last 5 minutes, about this very special rule. It's Article 17 of the Articles on the Responsibility of International Organization, that has been devised just to address situation of authorization to other international organizations. And it is the idea that if an international organization, in this case the United Nations, tries to circumvent its obligation by authorizing an international organization to carry out a given conduct, and it may incur responsibility if that conduct leads to a wrongful act, violations of laws of war, for instance. Well, the rationale and the policy consideration behind that provision is a bit unclear. The commentary, like most of the time, is very short and very hazy. Allegedly, it comes from the practice. The LC cites Bosphorus. To be honest, that's not my own reading of Bosphorus. And I don't know why the Commission is so hesitant to just say that this is progressive development and just try to hide this behind some very weird reading of the case law. I don't have a problem with progressive development. Well, whatever. The Commission has devised this rule, Article 17, so the idea of circumvention, the idea that the authorizing organization may incur responsibility by virtue of its authorization, because of having authorized another international organization to commit an act which led to a wrongful act. This comes with huge problem. Again, conceptually, it is extremely problematic. You have the dolus, the fault coming back by the back door, whereas we all know that we try to devise a system of responsibility short of any subjective element, but that's not my point today. My point is simply that when you apply this to specific situation of authorized mission, of authorizations granted to international regional organizations, it generates huge issues. Not only at the level of the UN, because you would have to prove the intention of the UN to circumvent its obligation, and with such vague authorization as we witnessed today, and as was discussed by Professor Christakis this morning, it's very difficult to see how you would infer an intention to actually circumvent this primary obligation pertaining to the use of force. But there are also many problems regarding regional organizations themselves, many problems at the level of international organizations. And I would just like to flag two flashpoints, two issues with respect to the application of this specific provision to regional organization. And I'd warn you, it's extremely technical, and I'm very sorry about that. Well, for this rule to be applicable, I believe that the wrongful conduct must fall within a use of force of a specific nature, which is a use of force for the purpose of collective security. It must be a use of force aimed at peace enforcement. It cannot be a use of force which has a defensive nature. And so therefore, the nature of the use of force will influence, impact and impinge on the application of that rule, that mechanism of shift of responsibility in Article 17. Now, this may sound a rather arcane point. And it's true that if you think about the NATO intervention in Bosnia, Resolution 846, there it was very clear what was defensive, what was peace enforcement, what was airstrikes for peace enforcement. That was very clear. But it's not always so. I mean, in some missions, you have dimensions which are peace enforcement, collective security, and you have other aspects of the mission which are just defensive. Or, even worse, you may have, and I'm aware now it's already 15 minutes, well, in some other missions you have states claiming that the mission is defensive and others that are claiming that it's peace enforcement. Just take the operation of ECOWAS in Liberia. Ivory Coast said, no, it's self-defense, whereas Nigeria said, no, it's peace enforcement. If you take Mali, a possible future practice of authorized use of force by a regional organization, well, you have a request by the transitional authorities, and you may have an authorization by the Security Council to ECOWAS. Then what's the nature of the mission? Is that invitation? Huh? Is that invitation? What's the basis? Or authorization? Well, this has a huge impact, in my view, on whether this shift of responsibility is possible. And that leads me to just the final point I want to make. I think there are issues also as to whether the organization itself has the status of regional arrangement under Chapter 8. I will not discuss that. But the only point I want to make is that the way you shape your intervention and the way you market it might influence the applicable law in terms of responsibility. So putting it even more bluntly, in a very cynical way, the narrative you use, the way you present your mission, may influence the regime of responsibility. And for instance, if you want to make sure that the burden of responsibility is shared with the UN, you have to make sure that your operation is an action of collective security. And you have to present it itself. And these are my 3 last sentences. So there may be variations of responsibility according to the narrative you use and the way you present and you shape your mission, whatever the actual practice is on the ground. And I think this is an issue that was, like many others, overlooked by the International Law Commission when it just rushed into drafting this extremely problematic provision. And this is just the last words. This is just a general problem with this article on the responsibility of international organizations. The more they come under scrutiny, and the more they are confronted with practice, the more deficient they appear to be. And really, we celebrated these rules as a great achievement. But again, as I said to the students the other day, after the party, the hangover. I think the more these rules are confronted to the practice, the more problematic they appear. And I think situation of authorized use of force by regional organization is, again, a very good example of how these rules have been thought and devised short of any consideration for the practical implication. Thank you.